Alright, hello and welcome to another criminal law capsule. And this criminal law capsule is going to provide a basic overview on sentencing tools. I am not, it's almost easier to talk about what I'm not going to do. I'm not really going to talk about how a judge decides which of these tools to use. This capsule is really just designed to give you a primer on the basic tools that are available, because there are a lot of them and there are a lot of particular statutory provisions to deal with. So there's a lot of detail here, and I want to give you a good overview primer of the types of things a judge can do when they are called upon to sentence an offender. So let's get into it. I'm going to assume here that we are past the conviction stage. The offender has been found guilty or has pled guilty to whatever, doesn't matter. And in every case, I just want to stress here, we are talking about somebody who has been found guilty. Later on, in another capsule or later on in this course, we'll learn about people who are found not guilty for reasons of mental disorder. And I want to stress to you that what I'm saying here does not apply. If you are found not guilty, no matter what you did or how awful it was, by reasons of mental disorder, you go into a completely different regime. What we are talking about here is people who are guilty of committing a criminal offense. Now, first things first, when we're dealing with sentencing, we are talking, it doesn't matter what happened at your trial, whether it was a jury trial or a judge-alone trial, it is always the judge who is responsible for sentencing. And by and large, that's true. What I just said is true, but I just want to make you aware of a feature in the criminal justice process that does, change that a little bit. And that has something to do with the way in which parties make decisions. And as you know by now, we have an adversarial process in which the Crown brings charges against a defendant, or known as the accused. And it is those parties who together bring a case before the judge and litigate that case, and they are the adversarial parties in this system. Well, the idea of the adversarial process is that both parties are adjudged with trying to come to a best result before that judge, and it also recognizes that if you can get both parties to agree, then the judge should, by and large, accept that justice is being done if you can get two opposing parties to agree. And that holds true in the sentencing process as well. And it is represented through something that is known as a joint submission. Essentially, what happens is, usually the parties don't agree. The Crown will put forward what they want, the defendant will put forward what they want. That's how a traditional sentencing hearing works. The Crown will put forward its position on sentence, the defendant will suggest what it thinks is correct, and the judge will decide. They can take either position or neither. The judge can decide. However, sometimes both parties will agree. Usually that will occur where there's a guilty plea, but sometimes it occurs in other situations. And if they agree, they make what's called a joint submission to the judge. And they say, we agree that the result should be X. Let's say a year in prison, just to make it easy. And where a joint submission is agreed upon, the case law makes it clear that most of the time the judge should accept it. Let's be clear that the judge ultimately has the authority to do what is best in the interests of justice, and that includes rejecting a joint submission. However, because the system of justice likes to get people to agree, joint submissions, there's a fair bit of case law that says joint submissions should not be rejected, more or less, unless they are manifestly inadequate. So what I'm saying is, as we go forward, I'll say that sentencing tools are up to the judge to decide, unless there's a joint submission. Where a joint submission is made, most of the time a judge will accept it, unless the submission being made is manifestly inadequate. All right. What tools does a judge have at their disposal? I would suggest that you open up your criminal code if you have one, and if not, go to the internet and call up section 730. We're going to start there. Section 730, I like to start from the beginning, or the lowest to the highest, talks about discharges. Discharges are the lowest form of penalty available, and they come in two forms, absolute and conditional. Let's start with an absolute discharge. An absolute discharge is the lowest possible penalty that you can get in the criminal justice system while still being convicted. Effectively, these are reserved for minor types of offending. They are only available for crimes that are punishable by a maximum penalty of 14 years or less. And essentially what the court is concluding is that yes, you committed a crime, but this crime was minor enough, given your overall record, that we are going to discharge you. And this is a very important thing. An absolute discharge means you are discharged without anything. You don't have to do anything further. You can walk out of the courtroom that day, and most importantly, you are deemed not to have been convicted of the offense. It's essentially like a freebie. You still have some sort of record. It still exists in some form. It sort of is there, but nonetheless, you're more or less deemed to have gotten one free kick at the can. And it's a really important thing to have, and it's essentially designed to recognize that people make mistakes sometimes, and we're going to let them go, but I can't stress heavily enough that discharges are not given out lightly. These are for crimes that are exceptionally minor. They tend to recognize that they are criminal, but nonetheless, they're small-time offending. You don't get a discharge for drunk driving. You don't get a discharge for beating someone to a pulp. Discharges are handed out for shoplifting or other types of minor offending for the first time. Conditional discharges are slightly elevated, and the reason is because conditional discharges have conditions added. Effectively, with a conditional discharge, the offender is put under a form of probation order, and they can be placed under all sorts of various conditions. And if they comply with those conditions, at the end of those probation order, whatever the term is, let's say, for example, it's a year, but it can vary, then they are discharged. So in contrast to an absolute discharge, they only get the discharge once the conditions are actually fulfilled. It's convenient for me at this time to bring up Section 731 sub 2, which is very, very similar. It's called a suspended sentence. The judge has the ability to essentially convict somebody, but suspend their sentence. We're not going to put you in jail. We'll just give you a probation order with conditions. The difference between a suspended sentence and a conditional discharge is that with a suspended sentence, when you finish all your conditions, well, you're free, you're finished, but your conviction continues to exist. Whereas with a conditional discharge, you're finished and your conviction is gone. You never got convicted. You are discharged from the court. So those are the lighter forms. Obviously, again, a discharge is the lowest. A suspended sentence is still a pretty light form of penalty. Nonetheless, even those types can be incredibly onerous to a certain extent. The conditions that can be imposed can range and vary, and all sorts of various conditions can be put in place. Take a look at Section 732, which lists the sorts of conditions that can be put into place. Sorry, Section 732.1. You have compulsory conditions to keep the peace and be of good behavior and appear before the court when you're ordered to do so. But the list of optional conditions is off the charts. You can be told to report to a probation order, abstain from alcohol or drugs, abstain from possessing weapons, keep up your support or care, and agree to all sorts of various things. The conditions can really go on. There's all sorts of pages. And, one of the problems, I don't have time to get into it now, is that a lot of people are put on a lot of conditions, and I can tell you from experience, one of the most common charges we have in our justice system is breach of condition. So obviously, once you get put on conditions, there has to be a way to monitor what happens if you breach. And what happens if you breach is you can get punished for breach. You can get charged with a new offense, which is breaching a probation condition. And once that happens, you get hauled back before the court with a new form of offending, or your suspended sentence gets taken away from you. So, these conditions are fine, and this sort of stuff happens every day, but obviously conditions that are onerous can be very difficult for people to keep up with. So be aware of that when you're thinking that this is a light form of sentence. Next up in Section 734, money. Fines. Very popular to fine people. You can fine people as a standalone offense, or in addition to some other offense like imprisonment. So for example, if you punish someone with prison, then you can also hit them up for some money. Obviously, fines are very popular forms of punishment with corporate offenders or with businesses, other things like that. Keep in mind that, as you might imagine, Section 734 sub 2 suggests that when you're punishing people, you should be satisfied that people are able to pay. Because the problem is when you fine somebody, if they don't pay, usually they're going to get imprisoned. You can imagine that if you fine someone $50,000 and they don't pay, the court gets pretty ticked off. But it makes no sense to fine somebody and then imprison them if they can't actually pay. So fining is a viable option, and it's used quite a bit, but it's only used really where it is appropriate to do so. I should add that in addition to fining, another form of monetary, I don't want to use the word penalty, is the idea of restitution, which is a newer idea, or slightly newer. It's not that new anymore. Restitution is available in Section 738 because a fine goes to the government. You're essentially paying the government for what you did wrong. Restitution is an additional form where you've essentially done something wrong to a private entity. And in those cases, there are rules surrounding the amount of money you can be asked to pay to somebody else. But once again, you have to make sure that they can actually pay this money off. You may also have heard in the news there are some other monetary options involving victim surcharges, where you have to pay some surcharge to the court. That's almost like essentially an conviction tax that they use to fund various victim programs or something along those lines. All right, we made it to jail or imprisonment, and that's where things actually get complicated. Let's talk about imprisonment. There is a lot to say, and it's very confusing, so I'm going to try and simplify it as much as possible. Here's what you need to look for. Every single crime in the criminal code, every one has the potential for jail. And let me stress, that doesn't mean jail is imposed, but every single crime, there's not a single crime that doesn't have the potential for jail. As I said, most times you get discharges, fines, probation, all that other stuff if the offending is minor. What are we looking for? Two things. Number one, what is the maximum? So you've got to look for the maximum penalty as it is set out. Number two, more and more popular are minimum penalties. So you've got to look as well for minimums because they're all over the place now. It used to be when I was going to law school there were 2 or 3 minimums. For example, murder has been punishable by a minimum of life imprisonment for long time, but minimums now are just, they sprout up everywhere. Every type of sexual offending has minimums. Drunk driving has minimums. You can go everywhere through the code and you will find minimums. Be aware, obviously, where there is a minimum penalty, that trumps the ability to hand out a fine, a discharge, a suspended sentence. If there's a minimum penalty, that's what you get, the minimum penalty or higher. So you got to be aware of that. Number 3. For certain crimes, there's more than just a minimum, there's more than just a maximum. There is something called a period of parole ineligibility. And this is where things get a little bit complicated, but let me explain. Essentially, the maximum and minimum terms that you get handed out are just your term of sentence. But those terms have nothing to do with the actual amount of time you will spend in jail. Sorry, I should rephrase. I don't mean nothing to do, but they don't usually represent the amount of time you will spend in jail. Say you get sentenced to a period of 10 years by the judge. 10 years is your sentence. But the period for which you will actually serve is covered not by your sentence, but by another act which has to do with the time at which you might be paroled. As you might understand or might guess, the idea of parole is to encourage you to have good behavior and the idea that we need to manage how many people are in prison at a given time. But to make a long story short, and I am generalizing hugely here just for the purposes of simplicity, let's assume that you are eligible to apply for parole after a third of your sentence. That would mean, for example, that you could apply for parole at about 3.3 years. And let's say you get it. Well, therefore, you only served 3.3 years of a 10-year sentence. And believe it or not, that's not as uncommon as it seems. Maybe you'll serve 5 years, maybe 3.3. Let's just say this, very few people, except the worst offenders, serve all of their sentence. It is very common, and the vast majority of the offenders get sentences only. In other words, what I mean by that is, when judges impose penalties, they tend to impose only the amount of time that the person is supposed to spend in prison, and they do not concern themselves with parole. Parole is dealt with by a completely separate act. It's not dealt with by the code, it is dealt with by the Corrections and Conditional Release Act, which governs parole. Once you're in jail, when are you going to get let out? However, for serious offending, the government has tried to change the rules, and they have set up rules that deal with parole ineligibility. And that means exactly what it says. So essentially, it allows judges for certain types of crimes to set a period at which you can't even apply for parole. Murder is a crime for which the penalty is life. But life means something much more akin to life in the case of murder. First-degree murder has a mandatory period of parole ineligibility of 25 years. For second-degree murder, it's 10, but the judge has the ability to up it as high as 24. And for multiple murders, the judge now has the ability to add the periods of 25, 50, as many as 75. So you can really get long periods in which the person can't leave jail because they can't even get the eligibility to apply for parole. And the second to last one, involving imprisonment, is a fairly recent invention which was designed essentially because we have too many people in jail and we're trying to cut down on it. And it's a much more controversial one because we sort of are worried about having people in jail because it costs too much, but at the same time, if we release people from jail, people start to lose their minds because they think we're doing things too soft. That is in Section 742, very controversial provision that deals with what's called a conditional sentence of imprisonment. And essentially, this is for a situation when a person is imprisoned, but nonetheless, they don't actually go to prison. To put it in ways that colloquial people will understand, it's home imprisonment. That's really what it is. The idea is that if you're convicted of an offense and it's of less than 2 years, so it's that reformatory situation we dealt with, you may serve the sentence in the community. And there are a whole list of situations, usually involving offending that's not that serious, in which that will take place. Let's just say that the court's commitment and Parliament's commitment to when this should happen varies over time. Their willingness for this to take place varies over time. It sort of waxes and wanes. But, by and large, it's meant for non-serious type of offending that nonetheless requires a severe sanction. So it's more than a fine. It's more than a discharge, it's more than a suspended sentence, but we don't need to clutter up the jail with your type of offending. That's the basic idea. So conditional sentences are another option that are available for certain type of offenders. And let's flip that and get to the most serious types of offenders there are. Usually we think we sentence somebody and we say, God, you're going to get 15 years, you're going to get 10 years. Boy, but this person is dangerous. Can't we just keep them in longer even though we can only convict them of what they've done? We now have mechanisms to do that, and they are called dangerous and long-term offenders. Effectively, what we are recognizing is that even though we've only convicted them of offense A or offense B, we recognize that this person is a danger, and if we let them out, they are going to continue to hurt people. These are, in some sense, controversial provisions, but in other sense, not that controversial at all, because they have fairly high thresholds, and you need to prove that the person in question is a danger to the public, or is going to continue to be a long-term offender. These are essentially where you're sentencing somebody and you're saying, instead of just punishing you for A and B, we're going to keep you there for as long as we can, because you represent a clear danger to the public. Dangerous offenders are very, very complex provisions. They require hearings because you're essentially getting new trials that essentially look at, is this person a continuing danger to the public? And I can tell you that these are very, very complex areas that are reserved essentially for the Paul Bernardos of our community, the really, truly dangerous people who simply cannot, under any circumstances, be released. Very interesting area, really requires a course of its own to explore properly. The last thing I want to touch on before letting you go, that while it is the judiciary that sets out sentences, it is the executive, or more importantly, believe it or not, the Queen, who has the ultimate power over sentencing in this country through the royal prerogative of mercy. That's actually set out, in the Criminal Code. Section 748 makes clear that no matter what a judge sentences you to, and no matter what a court of appeal confirms, you can always apply for mercy or a pardon to the executive, which is essentially the Governor General, but really, it's the Prime Minister. You are applying to the government and saying, we want mercy from what has happened. And I'm not going to tell you these are never accepted, because there have been situations in which mercy has been granted. It's a very erratic process. I'm not going to tell you it's accepted every day, but there are situations in which the royal power of mercy is used, and it goes back, really, this power goes way back all the way to the time when you could appeal to the king, and the king's will was, I will let you go because I like your face, or whatever. The power of mercy continues to exist. It's actually there as a residual power, and sometimes it's used quite effectively in situations where someone, might have been wrongfully convicted, or there's some lingering doubt, but all their appeals have been exhausted, and they go to the appeal for mercy, and sometimes mercy is granted, sometimes a new trial is granted, sometimes a pardon is granted well after the fact. So this power continues to exist as a residual power that is part of the Queen's prerogative, or the Crown's prerogative, really. That is an overview of the sentencing process, a quick one that gives you a little bit of an idea of the powers that are available to a sentencing judge. I hope it was useful to you and should give you some context for the way in which sentencing takes place and the difficult job that a judge has in making decisions on sentence.